always been subject to prosecution as adults since the beginning of the juvenile justice system in this country, going back to the end of the 19th century. There was always some mechanism in the early juvenile court statutes that provided for that kind of prosecution. But the changes that we have seen in the last 11 years, since 2005, are really of historic, groundbreaking proportions. I think that they are moving the ground beneath us, and the court has really created the framework for a whole new way of thinking about children in the justice system. And I want to be clear that I am deliberately using the term justice system or criminal justice system, because I think that the conversation that we are now having is really about how we manage and respond to and hold children accountable for behavior that violates the criminal laws. It will be addressed in some part of the justice system, which part of the justice system is something that I think we're all trying to sort out. The Supreme Court issued 4 decisions in the last 11 years, and those decisions go from Roper to Graham to Miller to Montgomery. Along the way, there was a parallel in JDB versus North Carolina, which was a case that dealt with police interrogation and how one factors youth into thinking about custodial interrogation under Miranda. I'm not going to talk about that today, although it is of a piece in many respects with the sentencing cases. But Roper and Graham and Miller and Montgomery are about sentencing. And the scientific information in the slides that Jen just shared with us were taken by the United States Supreme Court in the Roper decision and then in the subsequent decisions, and used by the court to really establish a new constitutional framework for thinking about sentencing of children under the Eighth Amendment. In the Roper decision, which eliminated the juvenile death penalty in 2005, the court looked primarily at the psychological research and behavioral research. Although the pictures of the brain were available to the court, the truth is that Roper didn't really focus very much on what the neuroscience was teaching us about children. But the court did look at the behavioral research, and it identified 3 specific characteristics of children and adolescents that it considered relevant to their rights under the Eighth Amendment. And those 3 characteristics were immaturity of judgment and impetuosity, their susceptibility not just to peer pressure, again, whether you can recall your teenage years or you have teenage children, you know that they never go anywhere alone. Everything is always done in groups, and much juvenile crime, almost most juvenile crime, is committed in groups. And so they also have an extreme susceptibility to negative peer pressure. And lastly, because we all grow up, adolescence is a transient time of human development. And because of that, kids have a unique capacity and a special capacity for rehabilitation, for change and growth and maturation. When the Supreme Court moved past the elimination of the juvenile death penalty and confronted life without parole sentences for kids in non-homicide cases in the Graham decision in 2010, it looked at the same behavioral research that it had considered, added on to that by now a slightly more mature body of neuroscience. And essentially what Justice Kennedy said, and Justice Kennedy wrote 3 of these 4 decisions. Justice Kennedy said the neuroscience simply confirms what the psychological research and the behavioral research had led us to believe about kids, and relied upon these same basic findings and characteristics of adolescents to eliminate or to rule unconstitutional life without parole sentences for juveniles who were convicted of non-homicide offenses and yet serving these sentences in the adult criminal justice system. The court said a couple of very important things in Graham that become relevant as we think about where we are today in thinking about extreme sentencing of children in the justice system. The court rejected life without parole sentences because it said, number one, it takes away any possibility of hope. And the court recognized that when you have adolescents in a prison who are condemned to die there, it affects how they relate to that prison environment. It eliminates opportunities for them to participate in programming because no one thinks they're getting out. And it affects their, in a very real way, their sense of humanity because of that lack of hope about the future. The court also said that because children are unique in terms of the fact that they are still engaged in this extraordinary process of human development, that they needed to have the opportunity to demonstrate growth and maturity. That whoever children are, whoever teenagers are, if they commit the most serious of crimes, they're not likely to be that person, will almost never be that person 10, 15, 20, 25 years later, and they must have a right under the Constitution to demonstrate that growth and maturity. And lastly, the court also held in Graham, again dealing with life without parole sentences in non-homicide cases, that juveniles had to have the opportunity, a meaningful opportunity, to re-enter their communities. And what meaningful opportunity means is something that continues to pose challenges. But in thinking about the work going forward post Miller and Montgomery, I just want to again sort of repeat those three ideas. There had to be hope, an opportunity for hope in this population. We have to give them an opportunity to demonstrate growth and maturity, and they must have a meaningful opportunity to be allowed to re-enter their communities. 2 years later, in 2012, the Supreme Court decided Miller versus Alabama. And in Miller, the court ruled mandatory life without parole sentences for individuals convicted of homicides that they were convicted of committing under the age of 18, that those mandatory life without parole sentences were also unconstitutional under the Eighth Amendment. This was a decision written by Justice Kagan. All of the analysis is identical. The court, again, is simply repeating the characteristics that it has identified as being markers of adolescence and childhood, and relying upon those categorical behavioral differences between children and adults to justify a distinctive Eighth Amendment analysis about what is permissible. If you're not that familiar with U.S. Supreme Court cases on sentencing of adults, we obviously know that we still have the death penalty in this country. Adults can be sentenced to mandatory life without parole, and they can be sentenced to life without parole in non-homicide cases. Those sentences are permissible still for adults in this country, but the court has carved out this special niche for children who commit these crimes under the age of 18. When Miller came down in 2012, there were 28 jurisdictions that were housing individuals who were serving mandatory life without parole sentences in homicide cases, meaning that they all had statutory schemes that provided for these mandatory sentences. Many of us involved in the litigation assumed that it would be retroactive because it seemed to pronounce a very distinctive and dramatic change in sentencing policy in this country. We were going from really only one sentence being available in homicide cases in those 28 jurisdictions, a mandatory life without parole sentence, to literally a day to life without parole. Once you take mandatory sentencing off the table, the court had endless discretion from the least amount of time to the most amount of time. We thought that was pretty dramatic. A number of key state Supreme Courts, including my state of Pennsylvania, Michigan, and Louisiana, those three states together house more than half of all of the juveniles serving mandatory life without parole sentences in the country. Those three state Supreme Courts held that Miller was not retroactive. And so in a state like Pennsylvania, where we have 500 juveniles serving this sentence, Michigan and Louisiana each have around, Michigan a little over 300 and Louisiana around 300. Those individuals received no benefit from Miller until the Supreme Court decided Montgomery versus Alabama just this year in January of 2016. And the specific issue before the Supreme Court in the Montgomery decision was whether or not Miller would be held retroactive. And the Supreme Court said that it was. And I want to just sort of talk for a minute about what the court said in Miller and in Montgomery, because it's very profound in terms of conveying what the Supreme Court thinks about extreme sentencing of juveniles, but will also, I think, prove to be very challenging in the implementation phase. As I said in Graham, the court talked about this idea of the need for hope, the opportunity to demonstrate growth and maturity, the opportunity to reenter our communities. When Justice Kagan wrote the Miller opinion and was confronted with whether or not we could impose mandatory life without parole on juveniles convicted of homicide, what she talked about was that although the court did not take discretionary life without parole off the table, Justice Kagan and the majority, the other four justices who joined the 5-4 majority, was very clear in articulating that the sentence should nevertheless be rare and uncommon. And in both Miller and in Montgomery, and Justice Kennedy wrote the Montgomery opinion, the Supreme Court used a couple of phrases to describe the category of juvenile offenders who could get life without parole, discretionary life without parole, in pretty extreme terms. And let me just tell you what the court said. These are the individuals for whom a sentence of life without parole might be appropriate. Those whose crimes demonstrate irreparable corruption, irretrievable depravity, or permanent incorrigibility. So if you think about those terms, I think you would probably say, I don't know who would fit that category, and who on the day of sentencing could we possibly identify, could experts identify as being someone whose crime demonstrates irreparable corruption or permanent incorrigibility. So on the one hand, the court has laid out a blueprint for a sentencing scheme that seems like everything should fall just short of life without parole sentences. What's happened both in the years since Miller came down, since 2012, as we're seeing the beginnings of implementation of Miller and seeing how states are responding in terms of statutory responses, it turns out that there's very much business as usual, I would say. I don't think that the news is good. I think that because we do live in a society and a culture that is highly punitive, we've all heard a gazillion times that we are the most punitive country in the world. We lock up more people than anyone else in the world. We have a culture of punishment. And what I've seen, as I have both had the opportunity to participate in some resentencing hearings, we communicate with our colleagues around the country who are working on these cases regularly. What we hear is that judges and prosecutors are still responding to these cases as murder cases. Now, of course they are. These are murder cases. But they're thinking about them as murder cases that require the most extreme sentences. And so how we get from permanent incorrigibility or irretrievable depravity to an understanding that that means that we have to think differently about how we sentence this population, I believe will take years. I mean, that's not a happy outlook. I think it will take years because I think it really is a culture shift that we need to undergo. Let me say a couple of other things about what I think the Miller-Montgomery landscape is creating in terms of what we, as certainly stakeholders, individuals who are concerned about how our justice system operates, need to be thinking about. Even as we go forward, if we eliminate life without parole sentences for juveniles convicted of homicide, we know that in many instances the alternative is a very extreme mandatory minimum sentence, 30, 40, 50, 60 years to life, which for juveniles is effectively a life without parole sentence. Certainly once you get over 40 years, many of these individuals will likely die in prison. But that's a challenge, how we get states again to think of something that doesn't just look like another form of life without parole sentencing. In Montgomery, what Justice Kennedy said in thinking about the implementation of Miller, now that all states are required to comply, was he said, you know, states, you could do resentencing hearings, but if you don't want to do resentencing hearings for the roughly 1,500 individuals who will now get the benefit of Miller, you could also just make everybody eligible for parole. Well, what does that mean? We have parole systems in this country that have not historically released children, and certainly have never released children who were convicted of homicide offenses when they were children. And so the parole process is one that has typically discounted and in fact provided a sort of negative value to someone who was a child when they committed their crime, when they were under the age of 18, because that suggested actually a kind of greater depravity, a greater likelihood of reoffending if in fact they were under the age of 18 when they committed that crime. We don't have parole boards that have been trained to think about how juvenile offenders do mature and grow, aren't factoring in the research that Jen and many of her colleagues around the country have now. Really, I think it's uncontroverted that most juveniles desist from criminal offending in their mid-20s, and probably I'm sure there's a lot of correlation and assumed correlation between what happens with natural maturation and brain development. The parole process isn't thinking about that because they've never had to think about that. So we are embarking down a road that is uncharted territory in terms of thinking about the potential release of potentially thousands of individuals at some point in their adult lives who have been convicted of the most serious crimes. And as we confront this challenge in a society in which we experience over-incarceration at every level, the importance of getting this right, I feel this very acutely, the importance of getting this experiment right in terms of being able to change our thinking about how we deal with individuals who commit the most serious crimes and how we deal with children who commit the most serious crimes is incredibly important. The last point that I will make is that because of the research that Jen and her colleagues have done and thinking about how the brain is continuing to develop, we know that the next bit of conversations that we're going to be having in rooms like this are going to be about what is the right boundary for juvenile court. Should that boundary be pushed up to 21 or 24 because of the fact that the brain is still developing and children and adolescents are simply still maturing? If we don't change the boundaries between the juvenile justice system and the criminal justice system, should we be thinking about sentencing differently? Even if all those 18 to 24-year-olds are in the criminal justice system, should we be thinking about a third way so that there is literally a different sentencing scheme in place for that population? Because they are different from offenders who are 25, 30, 35, who are committing serious crimes. They're simply not the same people. And what does that mean in terms of thinking about how our justice system, again, deals with crime?